2023, and the time is 6:02 p.m. and this is a public meeting of the PCCEP Settlement and Policy Subcommittee. Next slide, please. Okay, I will hand it over to Anne to handle introductions and the rest of this portion.
Thank you, Dory. Good evening, everyone. I'm Ann Campbell. I use she, her pronouns. And I think we want to start with having PCCEP members introduce themselves. I'll hand it to, now my screen just changed, sorry. I'll hand it to Gloria, and Gloria, if you can hand it to another PCCEP member, that'd be great.
Good evening, everybody. My name is Gloria Canton. I'm a PCCEP member. I've been with PCCEP since 2020, the end of 2020. And I'm on the SAP. Good to be here today, and it's good to see all of you here. I'm going to turn it over to Pastor Wisner. You're muted. Yeah.
Thank you, Gloria. And hello to everyone here. My prayers are that we're all safe and our families are safe in times that we're living right now. I'm Pastor Robin Wisner, co-chair of the settlement policy with Ann, as well as co-chair with the full committee, and also member of the race and reconciliation, race equity. And I'm going to pass it over to Tia.
Hello, my name is Tia Palafox. I use she, her pronouns. I've been a member of PCCEP since August 2021. I'm a co-chair of the Community Engagement Subcommittee. Thank you. And I'll pass it to Celeste.
Okay, there it is. Okay, my camera, I guess it still doesn't want to cooperate. Hi, Celeste Carey, co-chair along with Pastor Wisner. And I will pass it to, let me see. Is there a member who hasn't?
Leslie?
Leslie, okay, because I don't see anybody. Leslie, if you're here.
Yep, I'm here. Hi, everyone.
All right.
My name is Leslie Martinez, and I've been a member of PCCEP since August 2022. It's great to be here with everyone.
Thank you. And I don't know if there's any other PCCEP members here this evening. If there are, please introduce yourself. I don't see any others. Okay. If you could put the slide back up, that'd be great, Dory. So tonight we have a few guests with us, and what we'd like people to do is, if you're not one of the people that introduces themselves, if you can put your name in the chat, introduce yourself in the chat, that would be great. So if we could start with City, I see Heidi Brown is here.
Yeah, good evening, everybody. Hi, Ann, thank you.
Hi.
Heidi Brown, I use she, her pronouns, and I am one of the people at the city attorney's office. So thank you for having me here, and I'm interested and excited to talk to you all about a couple different topics.
Thanks for being here, Heidi. Let's see. Who else is here from the city? I think that's all I see at the moment. So I think I'll go to.
We have
oh, sorry.
Real quick. So we have me, Dory Grabinski, PCCEP project manager, and then also I will throw it to our other PCCEP staff.
Hi, Samir Kanal, Advisory Boards and Commissions Manager for the Community Safety Division. Thanks, everybody.
Thank you. Sorry. Okay, and then can we throw it to Mike Fromm?
Sure. Hi, everybody. Mike Fromm, I use he, him pronouns. I'm the deputy chief for the Portland Police Bureau. And I see a lot of familiar faces, but some I've never met. So nice to meet you over Zoom.
Thank you. And also, Tina Jones, please.
Good evening. I'm Tina Jones. I use she, her pronouns, and I'm the commander at our Professional Standards Division. Thanks for inviting me back.
Thanks for being here. And Dory, if you can put the slides up.
I think we just had DOJ left.
And DOJ. And I know Jonas is here. Jonas.
Hello, everyone. I'm Jonas Geiser. I'm with the Civil Rights Division in DC. Sorry about that. And I have a colleague here, Amy. I'll pass it over to her. Thank you.
Good evening, everyone. It's my first time meeting many of you. My name's Amy Senior. I use she, her pronouns, and I work with Jonas at the Civil Rights Division. Nice to meet you all.
Thank you all for being here tonight. I just wanted to take a moment before we do let's do the community agreements first. Let's see, do we have a PCCEP member that would like to read them?
I'll take care of it.
Okay. Thanks, Leslie.
Yeah. Listen actively and respectfully. Share airtime. Be present and open to new information and perspectives. Assume positive intent. Respect each other. Respect the group. Speak your own truth. Communicate directly, honestly, and respectfully. Ask questions to clarify. Call out bias and be okay with ambiguity.
Thank you. Next slide. Okay, so tonight we're going to talk about the role of arbitration and police accountability. Then we'll take a break. Then we'll talk about arbitration and body-worn cameras, and we'll have public comment. I wanted to start the meeting, however, taking note of the information that many of us read today that came out of Louisville, Kentucky. I just wanted to read a little quick thing. Attorney General Merrick Garland made the announcement Wednesday that a Justice Department report found that Louisville, Jefferson County Metro Government, and Louisville Metro Police Department engage in a pattern or practice of conduct that deprives people of their rights under the Constitution and federal law. This report said that the Louisville Police Department discriminates against Black people in its enforcement activities, uses excessive force, and conducts searches based on invalid warrants. It goes on with more information. Very troubling news. It appears that they will likely be under consent decree like Portland is. I also want to mention that Breonna Taylor was murdered by the Louisville police on March 13th, 2020. And so it's certainly a sad time. All right, so let's start with, can we put the slides back up? And I want to give a shout out to Dory for putting this together, all these slides. Thank you. So tonight our invited speakers are Heidi Brown, Chief Deputy City Attorney, Mike Fromm, Portland Police Bureau Deputy Chief, and Commander Tina Jones, Portland Police Bureau Professional Standards. One thing that we heard from the community, and many of us wanted to bring up this issue of the reinstatement of Officer Brian Hunsicker. Here's a timeline of this issue. I have been on PCCEP since I was appointed right before the murder of George Floyd. So I have been on PCCEP and seen a lot of things over the years. I do remember this very vividly, this incident that happened in March of 2021. then president of the union, Hunsicker, leaked a PBB report falsely accusing Commissioner Joanne Hardesty of a hit and run. Troubling. The city hires outside firm to probe, leak, and opens an internal affairs investigation. Hunsicker was put on administrative leave in May of 2021. In February of 2022, Mayor Wheeler fired Hunsicker. In February, the Portland Police Union takes a firing decision to arbitration. And in March of 2022, PPB Internal Affairs releases details of its investigation and finds Hunsicker and 2 other officers culpable for the leak. In February of 2023, last month, the arbitrator orders reinstatement of Hunsicker. And the following is a few pieces from, this one is from the Internal Affairs. There are many reasons Officer Hunsicker cited as the driving factors for why he shared the information. And one of those factors, he admits, was in response to Commissioner Hardesty's false allegation about officers setting fires during the civil unrest. Mayor Ted Wheeler said, as the investigation determined, Officer Hunsicker's actions also amounted to retaliation against a democratically elected member of the city council due to her criticisms of the Portland Police Bureau. And lastly, the Portland Police Association, which is Portland Police Bureau Union, said he has owned his mistake and held himself accountable by stepping down as union president. In firing Officer Hunsicker, the city was inappropriately turned accountability into punitive sanctions. This is a step too far, one that is unsupported by facts, reason, and objectivity. The arbitrator, Timothy Williams, said an injustice can be done when a good police officer is terminated for political or other reasons not justified by the facts. It is this arbitrator's conclusion that the discharge of Hunsicker falls into that category. The facts do not justify the decision to terminate his employment. So this is why we wanted to talk about this evening. And in kind of going over some of the information, as you'll see here, a review of the last 20 years shows arbitrators ruled in favor of PPB misconduct cases 80% of the time. And in the last, I think, the last 10 cases that went to arbitration, only 2 of them were not ruled for Portland Police Bureau. Aaron Campbell, a Black man in mental health crisis, was killed by Portland Police Bureau officer Ron Fashauer in 2010. And this helped I can't say the word, and I apologize. I guess it's been a long day at my work too. The DOJ's civil rights investigation, finding letter, and settlement agreement with the city. Ron Fashauer was reinstated as a PPB officer with lost wages in 2012. And all of this information that we've shared, to me is troubling. And it appears that it's a cycle that I don't understand. So tonight we're hoping to get a little bit of a better understanding. What is the role? What is arbitration? How does it work? As we all know, that PPA and the city are going to arbitration on the issue of body-worn cameras. So it's a topic that is at the front of our thoughts these days. Is there a pattern to the rulings? That is something that is troubling. does reinstatement have an impact on the culture at Portland Police Bureau? So I think I want to start with, I'd actually like to start with Mike Fromm, if we could, giving your perspective. You've been a long time Portland Police Bureau member, and kind of giving us like an overview of your thoughts on arbitration, if you would.
Yeah, I mean, honestly, my thoughts on arbitration are going to be somewhat limited. Arbitration is where everything that the city tries to do in terms of our discipline, where we want to be able to go in terms of deciding who works for the police bureau, or actually anybody in the city, it's where it runs smack into the intersect with state labor law. And we always know that at the end of the day, the arbitration process is going to be available there. There have been efforts to modify the law surrounding arbitration. I'll leave that to Heidi, because if I try to explain it, I will butcher it up so badly. But I mean, coming up through the ranks, I can tell you that, most officers are aware that if something happens that they end up being fired, that arbitration is that last chance to try to get your job back. And a number of times in the past, that has worked. And like you put out, and like the flyer that Mr. Hanneman put out in there, I don't think it's hard to go through the history of the Portland Police Bureau and the history of the city and get quotes from mayors, police commissioners, former chiefs about frustrations that they've had with the arbitration process.
Thank you. Heidi?
Yeah, so Anne, where did you want me to start? Do you want to start on what is arbitration, and I'll...
Yes, what is arbitration? If you could kind of give us an overview of what it is, the steps to that. It's interesting, the timeline, the length of time, that sort of thing.
So, arbitration is a process that is used that is outside of a court, but is similar in nature in that there is a decision maker, and that's the arbitrator. And then there is a hearing, and there's evidence presented, and the outcome of the hearing is binding on the parties. And so in this context, arbitration can happen in a number of different contexts. Like, people can have a contract and they can agree to resolve any disputes by arbitration. But in this instance, it comes to life under the collective bargaining agreement. And it's very rare for a union contract to not have a grievance and arbitration process. That's so almost all of our contracts do at the city, and most of the work that I've done over the last many decades, there's grievance arbitration is the method by which a union challenges action by the employer. And in this context, we're talking about when the employer takes a disciplinary action. This is the way that the union can contest that and have a third party decide whether that was right or not. And so the way it gets to arbitration is the city makes a decision about what should happen on a disciplinary matter. And after we impose the discipline, then at that point, if the union disagrees with what we did, they can file a grievance. And the grievance starts a conversation between the city and the union about whether they were right or we were right. And if we don't, there's different steps to that. And if we don't agree through those steps as they move up the chain on who's considering it, then we end up in arbitration. And I will tell you that there are while the arbitration cases, I mean, of all the discipline that the city meets out and that PPB meets out, most of them do not end up in arbitration. And so there are a number of actions that the chief's office takes and disciplinary action that they take that it does not end up in arbitration and the discipline stands. So what you're seeing is kind of the ones that are the most frustrating, certainly to me and to the Bureau and to the city. And I know to all of you as well, but I do want to assure you that there are many other ones that don't go through this process. And it's really up to the union on whether they decide they want to contest it or not and take it all the way to arbitration.
I wanted to ask one little quick question. How are arbitrators chosen?
So the Employment Relations Board, which is the agency, they're the agency in the state that has responsibility for interpreting the law over collective bargaining and for enforcing it. The parties get a list of arbitrators from the Employment Relations Board in most instances. And then generally what happens is you might get a list of 5 or a list of 7, and each side kicks one person off until you end up with the last person remaining. That was the process up until 2020, when a new law was passed. And that law changed the way that we select arbitrators for police misconduct cases only. And since that's what you're focused on, then I'm going to let you know what. So in that process, the way it's changed is the Employment Relations Board sends us one name. And if either side does not like that arbitrator, they can say, we reject that arbitrator. But you only get to do it that one time. And then the Employment Relations Board sends another name. And so let's say the PPA didn't like the first name, they could reject that name. The second name, then the city could decide, do we want to try for somebody else, or do we like this arbitrator? And so that's and if the city uses their decision to reject the arbitrator, that's the last one. And whoever you end up with on the third try, that's who you end up with. So it's a different process than for any other types of unions at the city. And that changed under the new law that Chief Frome was referencing a few minutes ago.
And are arbitrators attorneys, judges? What is their background?
Most of them are attorneys. There are some of them who are people who have worked in labor relations and disciplinary matters for years and years, and then they go into arbitration and sometimes mediation, and so then as long as they can establish to the Employment Relations Board that they have sufficient experience and expertise in labor arbitration, then they can get put on the panel. And I'm not really extensively familiar with what the Employment Relations Board's process is for becoming certified as an arbitrator for them. But most of them are attorneys, but they're not all.
Thank you. Is there anything else you'd like to share?
I did see a question from Barb, and I saw Pastor Weisner's hand up, so I'm happy to answer Barb's question just really quickly. The law was changed. There were a number of police reform changes made during 2020. And this was one of them, was to change the arbitration process. And in some ways it should have helped us, and does. It makes it easier for an employer of a police officer to be, it has a better chance of being successful at arbitration.
We could go with Pastor Weisner and then have Commander Jones. So go ahead, Pastor Weisner.
Oh, you're on mute.
I'm sorry. Thank you, Heidi and Chief Frome. Thank you, Heidi. The explanation of the role of an arbitrator has been given great description. I like to find out, because I'm thankful that we're informing the community how this process works. And there may be questions like mine, because I'm not very clear on the areas of how the arbitrator really kind of fits, other than what a personal arbitrator does on the behalf of what we do when we go to the labor board or some kind of agreement there. But you mentioned that they're in the union contract. It's in the union contract about the arbitrator. During the time that the contract is being negotiated and renewed and done, where that both sides are trying to agree with that, is there any discussion at that time about agreements of the arbitration and the officer's discipline, or how does that contract roll in when that there is? It just a standard and it just stays with the way that you described the law has to protect the right for labor, I guess?
So the right to go to arbitration is something that all unions will seek, and most unions have them in their contract. Every time a collective bargaining agreement is open, so they go for a term of years, however long the parties agree. So our current contract is a 4-year contract, and it ends June 30th of 2025. And so when it opens again, either side could put forth a proposal to change the grievance arbitration process. In order to resolve a disagreement over and now we're kind of jumping ahead to the body camera discussion, but a little bit, but when there's a disagreement between a group of employees that is not allowed to go on strike, and that is police, fire, and 911, those are the 3 types of public sector employees in Oregon who are prohibited from striking. The law then provides them another avenue to resolve disagreements, since they can't go on strike, and that is called interest arbitration. And so when you're looking at what's realistic and what are you going to win on in an interest arbitration, taking away the right to file a grievance and go to arbitration would be pretty challenging to win. It's pretty unheard of.
Thank you again. New language, interest arbitration for me. And so when there are negotiations about the arbitration, and the process I'm trying to follow is, what are those kind of challenges that the city sees that would different with the union in some cases? Well, let me say, especially when it comes to use of force, where we are right here, or areas of what it is, discipline, such as what happened in this case with the officer Hensinger. I know history has shown officers being reinstated after they have been terminated with the city for use of force as well. But the arbitrations always come back around and bring it back. So in those areas, are there learned experience that negotiates the contract of what it is that makes the areas of where that people will feel safer with the process when it's a decision like this?
Well, I think the legislative change that I was talking about, that was a good step in trying to make the process better when we're dealing with police misconduct. Because part of what happens is that in most arbitrations, an arbitrator will look at, is it more likely than not? Has the city shown that it's more likely than not that the officer engaged in this misconduct? There's other things they look at as well. Did they know of the rule that they were violating? Had you trained them on that? Did they violate the rule? So there's other things they considered, but the arbitrator is looking at the city has to prove their case and that it's more likely than not. What has happened in the past is that arbitrators on termination cases, and this is pretty common in termination cases for any union, not just police. So don't take this as something that they do just for police, but they will hold us to a higher standard when we're firing somebody. And it's because of the impact that firing can have on people. It can impact their career pretty significantly. So oftentimes when it's a termination case, instead of saying it's more likely than not, our evidence has to go all the way up to show it's clear and convincing. That's a harder standard to meet than more likely than not. One of the changes that the law made in 2020 is to say, no, arbitrators, you do not apply this clear and convincing. The city doesn't have to show it that high. They have to show it at more likely than not did the officer engage in misconduct. So that was a good change that we didn't need to try to bargain, and that is helpful to us.
Great. And again, I'm learning. So I really appreciate giving much of my answering most of my questions that are kind of naive to be saying, sort of trying to learn the process.
I appreciate your questions.
Okay, Celeste?
Good evening, all. Question for city attorneys and for you as well, Mike. And it's kind of, I'll ask them separately. So first, the police. I served on the union for a long time on the executive committee, executive board rather, as a trustee and executive committee member and things. And so I understand that when you receive a case for either arbitration or just representation, there's a process that is reviewed. And that's what the manager has written up as the cause for termination or discipline. So my question is, if a person has been fired by the police bureau, whether it's been performance, professional conduct, whatever, and you review all of the points that you need to review to make sure that it is it's a valid discipline or valid termination. My question would be, what is not being done to ensure that this sticks? Because I'm looking at the fact that most of the arbitrations that have removed replaced officers into their position had to have some underlying theme wherein the termination was not either properly done or was unjust or what have you. Has anybody done a study of what needs to be done for the disciplining body to make sure that they are doing this process correctly? Because I'm looking at this high percentage of return to jobs of officers who have been fired. I'm assuming that you've done all the background work and that the termination was justified, yet they're reinstated. Have we learned from what we've done wrong and corrected that so that you have a higher percentage of these officers not being reinstated?
Well, let me just talk about Hunziker in particular, if that's okay, because there's a number of cases that predate me and I didn't handle, and I don't know them at the same level that I know this case. But for this case, we had two bases that we terminated Officer Hunziker. One was for disseminating or sharing out the information outside of the Bureau. And then secondly was the retaliation.
Right.
And there really was a focus on the retaliation because he admitted he disseminated the information. And there were other officers who had also engaged in the same type of misconduct, and they had received, they had kept their jobs. and received lesser discipline. So you
Now,
see
was this for retaliation or for dissemination?
the dissemination. So
Okay.
on the dissemination alone, there was a question about whether we could uphold a termination. That would have been a pretty tough thing to uphold at arbitration with just that charge alone. Although we argued that that alone would have supported it when we went to hearing. But there was mostly we focused on, and you'll see in the arbitration award, which I know is quite long, that he focuses on the retaliation claim. And what he found was that Officer Hunziger was acting, although he got the information, but because of his role as a police officer, he in essence took off his police officer hat and put on his PPA hat and then talked to the reporter and engaged in what the arbitrator called public discourse. I just, I don't know how to get around that. I just disagree with the arbitrator and the ruling he made. And I just think he was wrong. I argued that in my brief. I don't, if anybody wants to see my 45-page brief, I'm happy to share it with you. But I made all those arguments and I said, you can't wear one hat, get confidential information and take off that hat and put on another hat and use that confidential information to get back at somebody because you didn't like what they did. And he disagreed with me and said that they were engaging in public discourse. So I don't really know what to say about lessons learned on this case. I'm frustrated with it. I feel like the arbitrator got it wrong. And so it's hard to say what lesson did I learn other than to say, do we not fire people when we feel like they violated our rules? I think we took the right action and we fought it hard. And I thought our witnesses testified really well. The mayor and the police chief were prime witnesses for us, and I thought they testified really well. And so I was pretty disappointed in the outcome.
So let me ask a question, because I appreciate very much that you have dotted and crossed, yet it came down to an opinion by the arbitrator. So here's a question then. Is it within professional conduct and professional standards for police officers to lie?
No, that violates their rules.
Okay, so to disseminate false information then is lying, correct? And I'm not asking, I mean, we all have our personal opinions about lies, because Lord knows white lies probably popped up in everyone's mind. But my point more specifically is, if as an official, a public safety official, no less, if an official of the city can lie with impunity, where does that leave us in terms of professional conduct and professional standards? And was that not enough for the arbitrator to recognize that, and I'm going to say it this way, I don't care if I upset folks, we're allowing an inferior performer on our police force? Because this is not an exemplary employee. This is actually as a former employee of the city, if I had lied or misrepresented any aspect of my job or information from somebody else, I would have been disciplined and probably fired. If I lied on my application when I was applying for access to law enforcement database, I was told not only would I not get, access, but I would be fired from my job. Now that says to me that there is a high standard, a high value put on truth. So I wonder do we need to ask PPA why they don't place such a high value on truth? Do we need to assail these arbitrators and ask them why they don't put such a high value on truth, especially with regard to public safety employees? Because my goodness, we're putting our lives in their hands every day.
So in this case, there was not, the rule that Officer Hunziker violated in our minds was the fact that he disseminated information. So there's a PPB directive that prohibits officers and members of the PPB from disseminating confidential information. And in this instance, he admitted that he did violate that rule. So when he shared out if you look at the investigation and you look at the arbitrator's award, everything showed that the woman who was driving the car incorrectly identified Commissioner Hardesty as the driver of the vehicle that hit her car. So that's what goes into a police report. The police report.
Right. Understood.
Right. And so what he shared out, we didn't argue that he shared out a false police report, because at that point, nobody knew. The point when he shared it with the Oregonian, with Maxine Bernstein, we didn't know at that point. Nobody knew, other than that Commissioner Hardesty was very adamant that she had not done it. And then PPB, and this is all in less than 24 hours, PPB determined affirmatively figured out it was not Commissioner Hardesty.
Was that prior to him speaking or after him speaking?
After. So he shares the information with Maxine Hardesty around.
Bernstein.
Thank you. He shares the information with Maxine Bernstein around 9:00 in the morning. Then noon, Commissioner Hardesty says, that is false. That's not true. That wasn't me. 2:00, Maxine Bernstein is challenging Officer Hunziker about whether it's true or not. And he takes a photograph of the computer screen showing that this complaint was filed. At 4:00, 2 hours later, that's when PPB determined that it was not Commissioner Hardesty. They found video evidence of that. And they publicly shared, no, Commissioner Hardesty was not the person, but he had already shared it out by then. So that's why he didn't get charged around the truthfulness, because we didn't learn, PPB didn't learn that it was inaccurate until later.
Celeste, can I just break in? I just want to make sure we get our other speaker.
Okay. Yeah, that's fine. I can pull it up later. Thank you very much, Heidi. Thank you for the answer.
And sorry to cut you off. I just want to make sure we have.
I understand.
For Commander Jones, Commander Tina Jones. Can you comment on our topic this evening?
Yeah. First, I'm glad that this is a topic of conversation. I think, like a lot of things in our, whether it's our discipline or accountability process, there are a lot of pieces to it. And like the last meeting I was on, they're complex, and a lot of it can be behind the scenes, and some of it's not very transparent. And a lot of cases it's not, because of the nature of the work. So I'm even learning some things here. The arbitration piece is, further down the road, like Heidi was explaining, from the actual internal affairs investigation. So a lot of, what our team does on the front end with these investigations then is the information that gets relied upon for both the disciplinary recommendations from like the police review board to the chief of police and the commissioner. And then, like Heidi was explaining, there's that appeal process from the union side. I want to comment because I could see a lot of the, chat things that are kind of flying by. But at the end of the day, to me, what I take away from a lot of this is a lot of times, there's an outcome that sometimes can take us by surprise or disappoint us, whether it's in the community and even internally in the police bureau. And a lot of times, we might see headlines and newspapers and things like that, but there's a lot of thought and process and work that goes behind it. So I was glad to hear, Heidi offering to share kind of her 45-page, I don't know what her brief probably is what she's referring to. And in this particular case, I believe, we had made public the case file for that. In certain cases, we do that, so that there's that opportunity for people to, read for themselves and see for themselves. And, the arbitrations at the end of the day, it's something that is external to the police bureau and the city and the union. They're supposed to be, fair and non, what's the word I want? Equitable. And, and it's binding, like Heidi was saying. So I do, it'll be interesting to see with the legislative change if there are differences in that. Ideally, I always kind of try and look at lessons learned, or, are there ways that we can try and internally improve and learn from things and get better. And obviously, these things erode trust between the police bureau and the community. And unfortunately, sometimes, it can just be one person or even a couple of people who do something that really, has a huge impact on eroding trust. And that's very frustrating and disheartening. So if anyone has any specific questions I can answer, that's fine. Otherwise, I know you'll have a lot of really important questions.
Thank you, Tina. I'm sorry.
Oh, so Pastor Wisner, do you have a question?
Yes, thank you, Tina. On the areas of what we always learn, and let me start this off with this at first, if I may, because I'm a preacher. In the church world, we always use the word God is good. And then the response back is all the time. My question is, why aren't we? My question is in the areas of, we're all people with hopefully the best intentions, doing what's right, because we learn even in the areas of what police officers and the areas of employment and things that you are doing. With the information, going back to the areas of the directive, when these are coming back and they have been reinstated, two questions. What is the morale around the other officers who feel strongly about him being back, or may not say that they want to be open about it? And then secondly, are there written, learned policies that are going to make sure that it is more clear the next time the arbitrator has a look at the policy?
I'm happy to speak a little bit about morale, and I'm just going to speak in general, not necessarily related to this particular case. There's a range of emotions. So I think a lot of times we like to lump community into a group, for particular groups, and we get lumped into a group as the police bureau or officers. And we have a range of emotions and thoughts about various things, including disciplinary matters. So, I think that, over the years, I've seen and heard, different cases of people being disciplined where there are times where people feel like maybe the discipline was fair, maybe it wasn't enough, or maybe it was too much, and people feel like it was more political in nature. As far as the outcome. And so I think it's hard to kind of lump the emotions into maybe one group per se. As far as policy goes, in this one, I'm kind of with Heidi. It was a bit of a unique circumstance given his role and kind of what the arbitrator, I don't know if it's arbiter, which one's correct. What the outcome was or the response was there. I think that that's something for us to take into account going forward. I don't know that in that particular case, there's an identified policy change, but we do always, solicit input for our policies when they're up for review. And if, there were ideas for that, then we do take those.
Thank you. I had one follow-up question for Heidi. Heidi, you did a great job of telling us about the 2020 law change about arbitration. And you said in 2020, if I heard you correctly, you no longer had to prove that higher level. You just had to prove more likely than not. And if that is the case, I'm wondering, with all we've heard and read about the Hunsicker case, he still got reinstated. So I'm not understanding how that happened.
That's because, and that goes back into this question of where the arbitrator found that he could take off his police officer hat. So he could use the police officer hat to get confidential bureau information. And then he could take that hat off and put on his union hat and engage in public discourse and public conversation, which kind of gets to like your First Amendment right to engage in public discourse, especially about public officials. There's greater protection for any community member engaging in conversation about their public officials, so that you don't have a fear of saying, well, I don't like what this person did and I'm not going to vote for them next time, or the different ways. So he focused on what he said was, he didn't even get to, it wasn't a question of whether we proved that it was retaliation, because he said, well, I can see his first thing. He said, well, at first glance, there's evidence that would suggest that this was retaliatory, because he said that he took these actions because of what Commissioner Hardesty had done. However, he said, because he was in a union role, he was allowed to engage in this conversation with the media because of his union role. I don't agree with his decision. So even though the standard of proof wasn't high, that didn't help me, because he went on a whole different tangent.
Thank you. Does anyone else have any questions?
I just have a final comment. And it goes toward, I think, what Celeste had brought out. The word is lie. And we all know what that means. And doing what's right. We train our children to be truthful. And in the place where this standard is supposed to be that bar as well, it's a shame that we have to come and try to argue whether a person lied or not. The other thought is the harm history has done when it comes to an African-American woman. That's a different conversation, but the attack was the same areas of what we in the community of African Americans, and I speak broad, of how the trust is not there. It's timely that the Breonna Taylor case and what took place there started in this conversation we're getting ready to have, because it's a shame that we have to have this conversation about just what to do what's right.
If I can address the pastor's comment, and I know it came up earlier. So we do, in professional standards, investigate allegations of untruthfulness, if that is something that, comes up in the course of an investigation, or that's what the initial allegation is, that someone lied. At times, and in this particular case, sharing information to say something along the lines of, there's an investigation involving, a hit and run, and Commissioner Hardesty, that was not inaccurate initially. With time, the information changed, right, with investigation. And so there are times where information is shared that's not done in a manner that would violate our directive. And it doesn't feel good, right? And I think, Pastor, you're really hitting the core of some of this issue that, you know, especially with race relations and distrust. I mean, it doesn't feel right. But at the end of the day, when it comes to policy and the allegations and you know, being able to prove something, we have to have that policy violation and be able to prove it. So sometimes people might act in a way that's not out of those boundaries, but it still, you know, can cause a lot of harm. So I'm not condoning anything in any regard. I just want to help provide that explanation that we do. I can think of, you know, some other cases where, you know, those things are being investigated. So we do take that very seriously.
If I can thank you again for that comment and make a final point to that. My mother was 90 who passed away, and one of the things in the ministry she did was talked about the beginning of Adam and Eve, where at the beginning of where that the buck was being passed. He blamed Eve. He blamed them. And then the serpent had nobody to blame in this analogy. But overall, it was excuses offered, but not accepted. The final point of where it is, the harm, this distrust, and continuing that we have to do better. I started off, we said God is good all the time, and all the time is good, but we are not. And that what we're needing to make sure happens for people who are being done like Joanne Hardison. I can't imagine how a Black woman will feel if she got nothing from out of that, and watch him to come back to serve her as if she had to be calling him. Thank you again. I appreciate your comments.
Thank you. Ashley?
Thank you. Well, apologies if this is a question was already asked, since I did join the meeting a little late. This theme about the union, obviously arbitration goes, is the union starts it for the fired employee, but so it's like there's this theme that the union really has this overarching power over the safety and stability of our city. And so, you know, I do plan to ask this question to the mayor's office for sure, but wondering, Heidi, Tina, I mean, how do we as a community, you know, or how does the union have so much power? And I think you said something, Heidi, about it's because they get this process because they're employees that can't form a union. And I'm just like, well, there's other companies and organizations that don't have unions, right? So why do police get this strong arm union? And I don't know if you can answer that question or help me figure out how to answer that question. I know it's coming up in our Police Accountability Commission conversations about how we really have create accountable standards for policing in the city, but we can't do it. We can't even implement something that was required by the settlement, which is body worn cameras, because of the union. And so how do we as community how do we get our fears and our concerns about mistrust heard over the union? Can we as a city say we will not have a police union? Like, can we do that? And how can I find out more about that?
So, I mean, there would have to be a change at the legislature in order to say police cannot form unions, because that's the law allows police to unionize. So it's controlled at that level.
The state level?
Mm-hmm. Yeah.
Okay.
And then just so you know, Ashley, so we were talking about two different types of arbitration. One has to do when you're bargaining, and what is the final collective bargaining agreement going to look like? For police, fire, and 911, because they're not allowed to go on strike, we go to this special type of arbitration that's called interest arbitration. That I will talk about a little bit later as we talk about body camera arbitration, because that's relevant there. But this about grievance arbitration, that is something that people negotiate into a collective bargaining agreement. And you see it in almost every single union that I know of. And I used to be on union side, representing teachers back years ago. We always got that in contracts. Celeste could probably talk about that too. Anybody who's been in a union, you always get grievance going to arbitration. The only times I've seen where you don't have it is like seasonal or casual workers, where they might have a contract that gives them some rights, but not full rights. That it just happens nationally. It's extremely common. So it would be hard to get rid of it unless the legislature said, no, you can't have it anymore for police.
Thank you. Are there any other questions, Celeste? I saw your hand up, but it's gone down. I wanted to give any last comments from our speakers. If they want to say anything, since we don't have any hands. Mike, do you have any last thoughts you'd like to share?
One thing I think I saw in the chat earlier that I don't know if we touched on, the PPA president is kind of it's a unique position in the state. And Heidi, you can tell me to shut up if I wander into bad territory on this one. But for forever, the PPA has a president who is paid by the Portland Police Bureau, and their full-time job as a police officer or sergeant or detective is to be the union president. And 100% of his time is spent doing union activities. And then there's a secretary treasurer that I think I think we pay him, but then the union reimburses us like 50% or something like that. So they have two people whose full-time jobs it is just to do union activities. And that's a little different than a lot of other places around the state, because most of the unions don't require full-time, and they have people that do it on the side after hours. They get certain, hundreds of hours a year to be able to do union activities. So when the arbitrator talks about him like putting on one hat and taking off the other, I don't even know if he has to take on and off the hats. I think he is this weird quasi position that is both police officer and union president all the time. That's something that would be subject to future bargaining. I don't think we get very far trying to get rid of it because we've had it forever, but that's just one thing I wanted to kind of point out about the way the PPA works.
I would just add that even for unions that don't have that, however, oftentimes what they have, and Celeste might be able to comment on this too, but they'll have somebody who gets elected to be the president of that local union, and that person can take time off to do their union activities. And there's a number of activities that a law that was passed in 2019 says the employer must pay while they're doing these types of activities, as if the person, they get to use employer paid time to do those types of activities. And that's for all unions, not just police. And so oftentimes they have these two different hats that they're wearing, and they're at work doing one thing, and then sometimes they're called in because, or there's an investigation going on, we need a union representative here. And so the person stops working and goes over and does the investigation meeting.
Yeah, a steward will do that, but and stewards do have certain federal protections, federal and state protections. But I must say this, and I was a steward for many years. You are not protected from violating your employer's rules and policies. So that's where I wonder where this arbitrator is coming from. Because again, if you all have dotted and crossed everything and you have a sound argument, this becomes problematic, because that can hamstring you and hobble any termination you make, no matter how sound your policy and legal argument is. And so I'm a little concerned about that, hearing it. But no steward is protected from doing anything that violates their employer's policies, even if they are acting as a steward. You're not protected in that case.
That's mostly true, although there have been cases by the Employment Relations Board where they said, like, a union steward acting in that role and yelling and screaming and cursing at the manager, that they have said that is okay. That wasn't
That's protected speech.
correct.
Okay, but that's not disseminating information that should be confidential.
Correct.
That's fundamental. I mean, if I can't disseminate information and I'm not an employee of the police bureau, but as crime prevention have access to information, and I could be terminated, why would that not be a policy even for a police officer? So that, I'm just looking at that and I'm thinking, okay, even if we do try to learn from what went sideways, there has to be some way of holding the arbiter accountable for these capricious and arbitrary opinions and decisions. Thanks.
Thank you.
And I see that, Heidi, you answered the question. He's been reinstated. He is no longer the PPA president, however.
Yeah, he resigned that role pretty early on in the investigation. So he hasn't held that role since then. So he was reinstated as a police officer. I believe at the end of February was the deadline when we had to reinstate him under the arbitrator's ruling.
Okay, thank you. Any other last comments, or we can move to our break? Well, thank you all. We'll take a 10-minute break and we will see you when we get back. Thank you.
in. I think Pastor Wisner, our other co-chair of the subcommittee, was going to head the second part of the meeting, if we were finished up with that first part of the conversation. So I'll hand it over to him. Of course, you could continue on if you had any unfinished questions. So I'll leave it to you.
Thank you. I did put my unfinished question in the chat for the chief. I didn't specifically put it toward there, but that was the one question that I wanted to put out also.
Would you like me to address that now, Pastor?
If you could, yes, please.
Yeah, okay. So by how does it impact the culture? We're talking about the reinstatement of Officer Hunsaker?
Correct.
Well, on the one hand, I mean, I'll be upfront. I think there's probably some officers that are very happy to see him back. You know, he was popular enough at one point to get voted as their PPA president. I think there's probably some officers that are still pretty angry over what he did. I don't have the same relationship with the officers that I used to. The higher up on the building your office is, the less they seem to want to bare their souls to you. But the what I can say is that he angered a pretty sizable number of people with what he did, and that's why he immediately resigned, because I think he knew that he was probably looking at a vote to get him removed. But like the bigger question of having another person get their job back through the arbitration process, what does that do to the collective culture of the police bureau? I would say that for many officers, they probably become numb over time to the very real threat that they might lose their job, because it's yet another example that is highly publicized of when the city tried to do one thing, but the arbiter overdid it. So I hope that answers your question.
It did, and since I asked that question, Ms. Ann, I'm going to ask you again, is there any follow-up on that, or could we have the follow-up from anyone that may want to, if that's okay with you, or should we just proceed on?
That's fine with me. I think you make the call. I think we are ready to move on if you want.
Okay, great. The screen where we on the second half, and thanks, Chief, really appreciate your candidacy and being here as well. Body-worn cameras is our discussion next. Next screen, please. This is our timeline, and it has been a topic of discussion as this is very important to a lot of people in the city. And since we're terming it as, you know, the camera identifying to actually saying what actually happened, and it's being able to be clear, but it's getting somewhere lost into this political legal jargon. We'll use the timeline as July 21st. The DOJ demanded the body-worn cameras for the PPB to be added to the settlement agreement. The mediation between the city and PPA on body-worn camera policy. February 23rd, the city PPA declared impasse over the body-worn camera policy, specifically allowing officers to review the footage before writing the report. February 23rd, the body-worn camera policy decision sent to the state appointed arbitrator. Possibly the DOJ could refuse to accept the policy that they side with. So the question, next screen, please, is what, looking for the next screen, it's going to be the question toward what does the arbitration process mean for the body-worn camera policy? And I'm going to invite our city, Heidi, and also our DOJ, if we can have you two, there we go, Jonah and Amy, to help us in this here question period and explaining that for us.
Well, I can start if you'd like. I do want to clarify one thing on your timeline. You said this, it said that the city and city, comma, PPA.
Could you go back to that screen?
Yeah. Okay, so it says city, comma, PPA declare impasse over body worn camera policy, specifically allowing officers to review footage before writing reports. And I just want to clarify that the city's, the place that we're disagreeing on is whether or not they get to review their footage before writing a use of force report. And the PPA says we want to review it in all instances of force, and the city's position is you don't get to review footage in any uses of force. So those are the two positions that the parties have declared impasse over and said this is our position at this point. So I just wanted to clarify that the city's position was not to allow officers to review footage before writing a use of force report.
Okay, thank you. Could you go from there?
Yeah.
I have thoughts, but I want to kind of give the open conversation first.
Yeah, so under the law, the law requires that, under Oregon law, requires that parties bargain over issues that are considered mandatory for bargaining. And this is one of the issues that we are required to bargain with the union. And so what the arbitration process means for the policy is that each side has their position about what the final outcome should be. And you've seen those are publicly available at this point.
Mm-hmm.
2 weeks before we go into hearing, each side has to give what's called a last best offer. And that is the law's way of trying to force the parties to get closer together before they go to hearing. Because once you go to hearing, the arbitrator has to choose either our offer or the union's offer. They can't take bits and pieces from each one and craft what they want. They are stuck with either one or the other. And so the law tries to push people to get both sides to get as close together as possible, and actually tries to force us to resolve things and keep labor peace. So in this instance, what the arbitration process means from my perspective is the arbitrator will decide whether the city's policy, final offer was the right one on pre-review, which is no pre-review, or is the union's the right way to go. Once the arbitrator makes a decision, and I can turn this over to Jonas, but he just posted it, then DOJ looks at, does this address the concerns that DOJ had that caused them to ask us to get a body-worn camera program and policy up and running? And if they feel that whatever the arbitrator decides does not address their concerns, they have the right to bring us back to court and have Judge Simon address the issue. Oh, I can't hear you, Pastor.
I'm sorry, I see Ann's hands up, but I think the sense that I have is that I'm not understanding why the review. I understand the trauma and going through certain things at different levels and all that's been said in the hearing, but from what is actually seen in the camera is no different from what is there. So there's a sense of not understanding, and this is why I'm having this conversation, and others in the community would like to hear, is it doesn't seem like it makes sense when the footage will say what it is, to review what it is, and it just a lot of questions about that. Ann, go ahead.
Oh, I want to hear from Jonas from the DOJ, and I just want to pop in this question: how is this arbitration process different than the one that was used with Hunziker? Because I know it's different. And then my other question: DOJ, from my understanding, DOJ can say they don't agree with the arbitrator, and then it goes back to Judge Simon, and then could he make the decision? So those are the two things I'm wondering, but I want to make sure that Jonas has time, and thank you for being here, everyone, tonight.
Thank you so much for having DOJ here. I really appreciate the opportunity. It's late here on the East Coast. Sorry if I'm a little foggy. I invite Heidi to speak to the arbitration question. The arbitration is not between the United States, the PPA, and the city. Rather, the arbitration is only between PPA and the city. That's something that's happening outside of our lawsuit. Our lawsuit is DOJ, the United States, suing the city. We came to an agreement, the settlement agreement, and as things have gone along over the years, we amended it. And that docket entry that I posted in the chat is docket entry 275. It's something that we all agreed to. That we work together, the city and the United States, and we try to come up with some good resolutions to some issues that arose in 2020. Part of that is answering the body-worn camera question that, frankly, Judge Simon raised when we first walked in the door together. He asked about those body-worn cameras. And I think PPA said that, not speaking for PPA, but just my recollection of it, has said for a long time, hey, we want body-worn cameras. And so we're looking for something that is fair and reasonable to everybody. The city needs to do what it needs to do with its arbitration. We're not going to affect that. But we've put a lot of things on record with the court already about what our expectations are for body-worn cameras. And hopefully it is something that makes every officer safer and gives the citizens and the members of the community in Portland the opportunity to see the work that is going on with the police officers. Heidi, do you want to address the arbitration issue? And then we can come back to the question about what happens if there's not a solution to the arbitration. Frankly, I'd rather us try to work out a solution before it gets there.
I agree with Jonas. I would rather us work out a solution and find a way to get to yes for all of us, and to get body cameras out on the streets. And Pastor, precisely because of what you just said, the cameras will give us a lot of information. It'll show us what happened, and will be very helpful in letting us know what goes on in an interaction between a community member and a police officer. So I think we all agree that that's very important, and the sooner we can get those out, I think the better for all of us. I did put in the chat the link to the law, and your question was like, how is this different? It's actually quite different than regular arbitration. So regular arbitration, the arbitrator is looking at what does the contract say? So if the contract says an officer may not be disciplined unless there was just cause for discipline, which is generally what they do, and that's what the arbitrator applies. On an interest arbitration where there's a disagreement over what the bargaining terms should be, there is a law that lists out, we go to this, like I said earlier, for groups that cannot go on strike, we have to go to the special kind of hearing called an interest arbitration hearing. And at that hearing, the arbitrator is required by law to consider primarily the interest and welfare of the public. Then secondarily, they look at financial things, which aren't relevant in this case, so I'm not going to get into that. They look at the ability of the government employer to attract and retain qualified personnel. And they look at the comparison, like what are other public jurisdictions doing with the issue that you're disagreeing on. So in that instance, you're looking at what are other, you might be looking at what are other jurisdictions doing with body camera policies. That might be one thing that will come up potentially at the hearing. Certainly, like I said, the interest and welfare of the public will be coming up. And I think the other thing that it seems potentially that the arbitrator might consider is retention and recruitment issues. Is the Bureau able to recruit and retain police officers? And does the body camera policy impact that?
If I may add one last bit here with comparison with other cities, this is a specific remedy to a specific issue in this specific case. So DOJ is not saying in all cases there must be this same sort of restriction on pre-review. I've added to the chat the letter that we gave the city that was eventually filed in court. 286-4 is the docket entry with the principles for body-worn cameras. And we've said in court, because this is a remedy to a violation of the settlement agreement from 2020, it merits the principles that we set forth in that letter. And we've also added a little bit to that record in the court. We've said with respect to live review, among other things, we want officers to be safe. So if you have a live view of the camera as it's being used after activated, it's a force multiplier. If officers are alone, somebody else can see them still, see what's going on. I don't think that's addressed in the letter.
John, I want to thank you again for being so clear on the separation of where the position is in the settlement agreement as well as this body-worn camera, because a lot of it can get lost in mingling it all up. But what I do know is that from the community, we're trying to, here at this group, is open this dialogue up to understand so that when the right information is not there, we have as a community the right information in front of us, and Heidi as well. At this point, I'm going to ask, is there any more that you would like to add to that, Jonah or Heidi?
So I want to respect your time if you have any questions for us. Thank you.
At this point, I will take the hands that I see. And I'm going to ask Dory or Ann or others to help me if I don't see the hands that are raised. I do see Ann's hands right now.
Thank you. I put it in the chat. How long has the city and PPA been mediating this issue around body-worn cameras? Because I think it gets to it's been going on in my mind for quite a while. And so we're going to mediation. And then I hear you, Jonas, as I agree, it's nice to work things out. But if you can't work it out, because it seems like you've been mediating this, the city has with PPA quite a long time, is there going to be a final decision? I think our community wants to know that.
Yeah, so Anne, we started bargaining body cameras, I believe it was either March or April of last year of 2022. And then as you saw in February, we had reached agreement on a number of the issues, and there's only one issue left. So we've resolved everything but this one issue. We asked for the list of arbitrators. We did that. Remember I said earlier how we get a list of 7 names? We did that thing of kicking off one person on each side, and we ended up with the person who was left. And we have reached out to that arbitrator and asked for dates from him. And we're currently waiting to get some more specific dates from him. But I can tell you that he was not available until starting in about July. It was after June 26th is what he had told us originally. So that we are in that process. We said impasse, we've done all we can and sitting there talking. Now, that being said, even while parties are waiting to go to arbitration, we still try to talk to each other and see, is there any way we can try to get this figured out? And so if there's any room for us to resolve this, we will keep trying to find that room to resolve it. But at this point, we've said we've tried and tried and tried. And we've resolved everything we can, and we just aren't able to agree on this final issue at this time. And so we'll keep moving it forward to arbitration, but in the meantime, we will continue to talk and see if we can resolve things, as Jonas says.
I'm gonna just thank you very much, Heidi. I'm gonna go to Ashley's hand that I see there. And then I'm gonna say this before, is that what is specifically the disagreement when it's so obvious there? That's the part I think that's really in my mind, I'm losing. Why can't we agree? There's something there that's not ringing my bell.
So what I can tell you is what our final offers say. And so, and you can look at what the DOJ, also their letter that they wrote. So DOJ, in their letter, they wanted for officers to write a report in any use of force case, then review the body camera footage. And then if there was some difference between their initial report and what the officer saw in the body camera footage, they could write a supplemental report. The city, in our final offer, what we said is the officers are required currently to give a quote, full and candid account. This is in the settlement agreement language. They're required to give a full and candid account when they have a use of force. And what we said is, when you give that full and candid account, we're going to record that, and that'll be your statement. Then you can go watch the footage after that, and then you can, supplement it or do whatever you want with it. Other than for deadly force, in that instance, we said we will keep our current process in place. And the union would like to have access to the body camera footage in all force cases before they write any police reports. That's the difference, Pastor. The reality is the footage is going to show what the footage is going to show. The question is, and the issue that DOJ has raised is, we would like to hear, what is the officer's recollection? This has been the city's position. What is the officer's recollection without looking at things and without distorting that memory? What do they remember about what happened that led up to this use of force, and why did they feel the need to use force in that instance? And get that, we said, let's get that information first and find out what you recall without looking at anything else. And then once you've given that statement, then you can look at the footage, and then you can correct anything if you got something wrong.
Has that process changed since the Kendra James? And I specifically point to Kendra James' case, where the officers went to Applebee's to get their story and then came back and was interviewed.
Yes. So in a force event currently, and Deputy Chief Frome and Jonas is very familiar with this policy as well. When there's been a use of force, the officers are required to call in a supervisor, and the supervisor comes out on the scene. So people don't leave the scene, they all stay there and they stay on scene. And then the supervisor comes out to the scene, and that's where they give that full and candid account. And then afterwards, they can go back and write their police report, but they have to give that full and candid account first. It's just at this point, that full and candid account, it's not recorded. It's just verbally, the officer is giving that account to their supervisor.
But before, it used to be recorded. Is that right? When they was in the room prior?
No, it's never been recorded. The only point where they get recorded is when internal affairs, if they do an investigation. So for deadly force, there's always an internal affairs investigation, and they go out within 48 hours and interview the involved officer and ask them questions about what happened and all of that. And that that interview is recorded. It's part of the administrative investigation into whether or not there was misconduct.
And the reason I asked that, and thank you so much for indulging my question. Ashley, I'll go back to my other point later. I don't want to hog up the time. Ash.
If you want to finish, that's fine, Pastor Robin.
Okay, thank you, Ashley. And the reason I was specifically saying that, Heidi, is because I heard in the hearing, a gentleman comment was that all reports have always been written and the process has always been that. And now we want to look at the video or the camera and then come back. And then, so I was confused that what the Kendra example was, is that a person on the scene is writing the report now. And then thank you for clarifying the internal affairs piece of recording the information, because during that time, I remember reading through it, there was a lot of changes that were being stated in that actual transcript of the Kendra James. So the camera obviously will say what it is. And there, I believe the community believes what we've seen here recently with the Nichols, as well as with the George Floyd, gives the sense of where that we can trust that more so than saying it and then reviewing it and then coming back and changing it if it needs to be. So Ashley, thank you.
Great, thank you. I just had a couple of clarifying questions and then I had a comment for the subcommittee or question for the subcommittee. And maybe Heidi, you can answer this. I imagine you can. So this arbitration process is an interest arbitration process. I just wanted to confirm that.
That's what it's called. Yeah. Interest arbitration.
Okay, thank you. Because this is something outside the standard bargaining contract process.
No, it is the state law that provides for the way that bargaining will happen for groups that are not allowed to go on strike. So police, fire, 911. So it's under the state law.
Okay.
I put the link to the state law in the chat. It's somewhere up, but if you need it again, I'm happy to put that in there again.
No, I grabbed it. Thank you.
Okay.
Yeah. And then, I think something that I learned tonight, and as a PCCEP member, I guess maybe I should know this, but as a new PCCEP member, I'm going to give myself grace there. So the arbitration process will happen. There'll be a decision, and then the DOJ will have a chance to examine it. And I guess I didn't know that part, and I didn't know that could actually go back to Judge Simon. So it's really interesting. And it just leads me to wonder if, this is just like the PPA, really stretching out the inevitable. I think it's pretty clear what's being written in the settlement, and maybe it's not that specific about being able to see the video before the report. But I think once it goes back to Judge Simon, it goes back to the DOJ, like the argument of why the city's position is right will come forth, and they'll have to do that. They'll have to move forward the process, and the city will have to get its way if the DOJ is involved. So I just wanted to, that was just interesting, and maybe there's more for me to learn there, but that eventually this will go back back into the community's hands in a little bit more sense than it is right now, it feels like. So I just wanted to noodle on that, and I feel like I just learned that, and it's really interesting because when we think about why we're here, really it's just the PPA trying to drag its feet on an inevitable person, but maybe I'm not seeing that right. But so there's that comment maybe / question of if that's a right summary of what I learned today. And then really the question to the subcommittee is, what do we do? What do we do now? What do we do what are the powers of PCCEP to, is it to engage more community on this? Do we write another recommendation? I don't, I'm asking because I think that our charge is to be activated and to be action oriented. So just want to put that out there, and, maybe public comment, we can get some more ideas that way too. So thank you.
Excellent, Ashley, and those comments that were very much so, as I'm learning, just like you are, very educational. And that is the ideal of what I'm hoping everyone is doing in this process of arbitration. I'm not a lawyer, as presently many of us. We all have come with, again, the good intention that everyone is wanting to do right, but we are trying to all come together and learn how to hold everyone accountable to what's right. And this is something that is not in our lane, but we thank Heidi and Jonah and Chief and them being here. Jonah, your hand is up.
Yes, just very briefly, I just wanted to set expectations a little bit. I don't want to assume any bad intentions of PPA, or just like you, Pastor Wise, I want to assume that everybody's trying to work toward a good common end. The expectation can't be that the inevitability of Judge Simon ordering something that is palatable to DOJ in the city. The expectation should be that it is better to avoid a potential conflict and appeal down the road if we can resolve something that delivers justice now rather than delaying the potential of litigation for years to come. Justice delayed. We want to avoid that, right?
Right.
We're after common goal here together.
Excellent, excellent. I don't see other, is there more hands there? And we now like to open it up for questions and answers from those who have more. And we do appreciate those who are here to help us ask questions and again, learn more. So at this point, if you don't mind using your electronic hand raiser or something that says you would like to ask the question, we can acknowledge you from there and keep it in an orderly place. I still have the screen in front of me. And can we get the other, so I can kind of get the gallery? There we are. I see it. I had to do it.
I don't see any hands up right now, but
so as a reminder, for open public comment, we can hear comments on anything shared tonight about this agenda or this meeting, or also any other PCCEP business or things you would like us to consider, anything else under our general scope of work. So we hope to hear your comments this evening.
Thank you, Dory. I noticed Jasmine from Cable has a comment in the chat, and I will like to ask if they would like to resubmit their public or say something about what their questions were or their thought. If not, I don't want to put you on the spot.
Yeah, sure. Hi, everybody. Jasmine. Hope you can hear me. I see a green box around my thing, so I'm guessing it's so. So yeah, we did, KBOO has been following sort of the body camera story with the Portland Police Bureau for many years now. There have been several rounds of listening sessions and stuff like that, and it's often come back to this question of officer review of footage and whether body cameras can really contribute to accountability if this piece of pre-review is in place. And there are many people, including the ACLU and other groups, that think that it can't, that ultimately compromises the efficacy of a body camera program. So we reviewed the body camera policies of other agencies within Oregon and found that the vast majority of them are written by a private company called Lexipol. You can look at the policies for other cities in the state of Oregon that have body cameras already, like Gresham and Beaverton Eagle Point and Bend and lots of other cities have them. And you'll consistently see that the language around officer review of footage is the same because Lexipol holds the copyright on those policies, not just the body worn camera policies, but the policies that are used by that agency. So that's why the question of, what is the sort of best practice or what are other jurisdictions doing is kind of troubling, specifically in a case when you have an agency whose interest is not the constitutionality of the people, but the limiting of the liability of the agencies that it's working with. So Lexipol's not interested in making sure that their policies support the constitutional rights of the people. They're interested in making sure that their policies limit the liability of the police departments that they're working with. If that makes sense.
It does. And is there a response?
Well, I just wanted to share that to remind folks that under the law, it says the interest and welfare of the public is the primary consideration of the arbitrator. So that's the first thing they consider. So I was just giving you a couple things of the secondary factors, and comparator information is by law something the arbitrator considers and that I expect we will be discussing at an arbitration. Jasmine, I think, you are correct that Lexipol, many jurisdictions use theirs. I think people could take somebody else's and then edit it however they wanted. The city came up with our own policy, but you're right that that's part of the impact of it, and that's something that we just have to face. And we look at we will keep focusing on the interest and welfare of the public.
Thanks. Thank you, Heidi. Barbara.
Can somebody explain? I don't know who would do it. How did this Lexipol? I never heard of this Lexipol, and how did they get involved in this? I don't quite understand what their role is. And like what kind of? So they have a copyright. Do you have to use their book?
Well, I don't know if it's appropriate for me to respond. Is that okay with the moderator?
Go ahead. Go right ahead.
Yeah. So yeah, I definitely want to point out that the Portland Police Bureau does not use a Lexipol policy. But the point that I think I'm trying to make around the significance of other jurisdictions using a Lexipol policy and them holding the copyright is that it makes it very easy to see which jurisdictions' policies were written by Lexipol, which means it's very easy to see how that policy came into being and who influenced it, right? Lexipol is not not accountable to the public in any way. It's a private company. They have had some transparency questions in the past. So the point really is not that the PPB is using Lexipol's policy. The point is that if we consider what other agencies are doing as quote unquote best practice and use that to dictate what policy the PPB has, then we could end up in a situation where we as Portlanders are being governed by a policy that was written by Lexipol instead of one that is in keeping with or that was influenced by Lexipol instead of one that was influenced by what Portlanders want, I guess is the best way to put it.
Would that be pointed out in any discussions in court or anything that it was Lexipol that wrote it?
I guess that would go to ID or.
Yeah, certainly the city can talk about where policies come from. And if all policy, if all Oregon policies look like they come from Lexipol, and I'm sure Jasmine has done her homework on that, then that's absolutely something the city can point out. I think that, like I said, it's one of the factors that the arbitrator considers under the law. It doesn't mean it doesn't mean it is the defining factor.
Okay. Thank you, Jasmine, for bringing this up. And Heidi for responding.
Well, is there any other hands? Barb, you can lower your hand. I see their hand again. I didn't know if it was just in any of the members of the PCCEP, would they like to have any comments or thoughts? Members?
I could make one little comment. I'm still wondering, and maybe I didn't hear it correctly. So if it goes to arbitration and arbitrator rules, and then the DOJ doesn't agree with that, then it goes to the Judge Simon, and then he would make a decision. I'm a little unclear about that piece.
Under the settlement, I'm sorry, may I respond?
I was, yes, Jonah, yes.
Thank you. Under the settlement agreement, the United States reserves its rights to enforce its notice of noncompliance from April 2nd, 2021. So essentially what that means is we go back to the judge and say, either we agree or we disagree with the body worn camera policy that the arbitrator came up with. But principally, we can't change the settlement agreement's requirements for full and candid force reporting and lack of that collaboration in those level 1 uses of force, where we say have a communication restriction order. That's the specific term in the settlement. We can't change those requirements in the settlement agreement by having a body worn camera policy from the arbitrator that conflicts. The settlement agreement governs, it's federal law, supremacy clause. Everybody has to meet that settlement agreement as currently written. If for some reason there were a ground to change the settlement agreement, we could discuss that later. But we would go back to the court and we would say, here's the policy that we agree with or disagree with. And if we disagree, we may at that point, depending upon authorization, ask the court to enforce the settlement agreement. The judge can enter an order. So the judge says, okay, here, I order this. That doesn't mean that's the end of it. PPA is a defendant intervener in our case. They could appeal to the Ninth Circuit. Then it becomes a question of whether or not the city can enforce the body worn camera policy that we want during the pendency of the appeal. Appeals can take a long time. My interest in avoiding that justice delayed, we've seen in this case and in others, justice delayed is what? Is justice denied. And so we don't want to get to that point. It'd be a much better resolution if we got to the remedy first. Our interest is not in trying to be mean and force people to do things. Our interest is trying to get to a good, durable remedy that the city is going to keep and that will benefit the effective constitutional law enforcement and the city for the people of the city.
Thank you, Jonah. And a comment that I would say in that, as one of my mentors and favorite person in history, Jesse Jackson, says, let's keep hope alive. I believe, Heidi, you in agreement with that. Is that right?
100%. Thank you.
No stalemate, no stalemate.
Yes.
I'm looking across and trying to see. Dory, I'm looking at a little body language there. Maybe I'm past my time, but
I do. I saw Ashley's hand real quick. We could hear from Ashley and then wrap up here. Yeah.
And I'll just turn it over to you at this point after I actually speak. Ashley.
Yeah, I just wanted to throw out there a little bit separate from the topics we were talking about tonight, just the news today that sort of come out about the city not really doing its due diligence for the Truth and Reconciliation Project, which was a direct recommendation from PCCEP before my years. And, a little disappointed we didn't bring that up tonight because my understanding is that recommendation came out of the Settlement and Policy Subcommittee. So I just want to put that on our brains because that's a PCCEP related recommendation that the city is violated and is not. And I have some questions about it. I don't want to obviously take up too much time tonight, but hopefully we can talk about it in the full committee meeting next week.
I should be able to say to you that two things to answer two thoughts that you have. One is that we will be talking about it and trying to bring up more, and it's not overlooked. The other is also getting back to you after talking with Ann. And Ann, I'm going to let you say some words of what you asked for as next steps so we can all come back and try to be able to, as a group. And I want to also say we are a team. We're not divided. We are all living in the same city, community. And I have a very good feel of what we all bring in trying to make the police better, our families safer. And again, the things that we do here to learn. And I had to do a lot of that in the 30 years that I was doing, where that I had no, as a Black man coming up from the South, no trust in police. But I'm now in a place in life that I do know that people are good. And I'm, like what Jonas said there, hoping to keep that in my scope of life. And I'm going to give it to you, and then Dory.
Thank you, Pastor Wisner. I just wanted to quickly say to Ashley, I agree with you. I actually worked on the recommendation, Truth and Reconciliation, with previous PCCEP member Taji Chesamet. I also was contacted by Andre Miller of John Hardesty's office and asked if I would help score the submissions. That ended up not even happening. I was never contacted, and as we saw today, what happened. So definitely, we will be discussing that further. But thank you, and thank you everyone for being here tonight.
I just want to put this out here really quick, because I hope we do put it on the next agenda, because there was like this recommendation in 2020, and then there was like things that the mayor was going to do. And I'm just curious, has that ever been done? So that's really good to know, Anne. Thank you.
Well, Dory,
yes.
The conversation is where that the city council, if I understand it right, has approved all the recommendations. We just have to figure this going to next steps. And again, Ashley, because we're all are here and learning and moving forward, that is a good discussion to bring to this group as well. Dory, am I right? Keep me in line if I'm wrong.
Has the city adopted all of the PCCEP recommendations? If it's not all of them, it's definitely most. And so I think the full PCCEP co-chairs have been interested in the subject of an adopted PCCEP recommendation versus a fulfilled one, because in the compliance reporting, the city responding to PCCEP recommendations, that is compliance criteria. And so the PCCEP co-chairs have been discussing this issue. And the Truth and Reconciliation Commission is obviously, it's in the news, and it's but they had been asking this question about that particular recommendation, for example, even before this breaking news. So, and I know others of you, like Anne mentioned, have actually worked on that recommendation. So, I think this will certainly be discussed moving forward, and will probably be an ongoing project for you all. But with that, I think, something to look forward to, work to come for sure, and a really important question. So I want to honor everyone's time tonight, but I thank you all so much for being here and for the really informative discussion. Thank you to our invited guests, Tina Jones, who left us a little while ago, but also Chief Fromm and Heidi Brown. And to, yes, all of our PCCEP members of the public, and our accessibility support. And we hope to see you at our next PCCEP meeting next Wednesday on the 15th.
Thank you. And just before you do this,
Jonas too.
Oh, and yes, thank you. Thank you, Jonas and Amy as well. Yeah.
I don't know if I overlooked Leslie's hand. That would concern me if I did.
I did drop my comment in the chat. I just wanted to address Jonas's last comment. I'll be very brief. That while the hope is that the agreement is reached, I just want to be clear about who is ultimately delaying and denying justice, because justice delayed is justice denied, right? But the community and social justice experts have been extremely clear about what body-worn camera policy should reflect in order to really ensure public safety. And it's not the community, it's the PPA that is resisting that mandate. So I just wanted to, I dropped it in the chat, but I just wanted it to go on record.
And I wanted that to be stated for you, Leslie. And again, thank you to everybody for your time. And again, from myself, not speaking for everyone, my prayers is that your family and friends are safe in times that we're living in. Have a great night, everybody.
Bye. Good night, everybody. Thank you.
Recording stopped.